When creditors are chasing, directors should avoid relying on memory. Pressure can make everything feel urgent. A supplier wants payment. HMRC may be writing. Payroll may be close. A lender may be asking for information. A landlord may be threatening action. In that moment, the director is usually trying to keep the business moving. In those moments, the aim is to keep people paid and avoid making the position worse. But if the company later enters liquidation, administration, or formal insolvency, some decisions may be reviewed with the benefits of hindsight. That does not mean every difficult decision was wrong. Directors are allowed to make commercial decisions in difficult conditions. The problem is that if there is no record of what was known, what was decided, and why, the explanation can become confused later. So the first practical rule is simple. Build a decision record while the facts are still fresh. Start with the basics. Keep a current cash position. Not just the bank balance on one day, but the cash expected in, the cash due out, wages and rent. Include suppliers, HMRC, finance payments, and any legal deadlines. Keep a creditor list. Show who is owed money, how old the debt is, and whether there is a dispute. Determine whether supplies are critical, and whether any creditor has taken formal action. Keep HMRC separate. VAT, PAYE, national insurance and corporation tax are different pressure points. Directors should know what is overdue, whether returns are filed, and whether current tax is still being paid. Keep payroll dates visible. The business needs to know whether payroll can be met without making unrealistic assumptions. Then record the decisions. If one supplier is paid before another, write down why. Was the supplier essential to completing a job? Was there a retention of title issue? Would non-payment stop the business trading? Was there a dispute with another creditor? Was the payment needed to protect value for the company as a whole? The point is not to create a defensive essay. A short, dated note is often better than silence. Next, keep advice records together. Record when you spoke to an accountant, solicitor, or insolvency practitioner. Record when it happened, who was involved, what information was provided, and what next step was suggested. Do not turn advice notes into something they are not, but do keep evidence of the conversations that shape decisions. Another important area is cash flow versions. A forecast from 3 weeks ago can matter even if it later turned out to be wrong. It may show what the directors believed at the time, what receipts were expected, and whether rescue looked realistic. Save versions rather than overwriting everything. If the forecast changed because a contract was lost, make that visible. A timeline is often much easier to understand than a bundle of disconnected spreadsheets. Directors should also keep a record of connected party issues. This can include director loan accounts and payments to connected businesses, include repayment of family loans, asset sales, and personal guarantees where a director might be affected differently. That does not automatically mean something has gone wrong, but these transactions can attract attention, so clear records matter. The same applies to new credit. Record why you believe the company could meet those commitments while pressure was increasing. What work was expected? What funding was due? What sale was being negotiated? What professional input was taken? Again, the aim is not to promise a particular outcome. It is to make the decision path easier to understand. A useful director record pack normally includes a creditor list, HMRC letters, bank position, payroll dates, and cash flow forecasts. Add advice notes, legal letters, payment reasons, director loan records, and personal guarantee documents. If pressure is live, build the timeline in order. What changed first? When did cash become tight? When were deadlines received? That timeline can make the next conversation with an advisor much more efficient. Preparation is not advice. Debt Decoded can help directors prepare and organise the questions. It does not provide legal, insolvency, or regulated debt advice. If there is live legal action, enforcement, a winding up petition threat, or investigation contact, speak to a suitable professional quickly. If you need more information, guidance, and tools, visit www.debtdecoded.co.uk.